Hello and welcome to the Money and Banking Law Podcast with Joe Silvia, brought to you by Duane Morris, an international law firm with roughly 30 offices and 1,000 lawyers all over the world. I'm your host, Joe Silvia. I'm a former Federal Reserve lawyer who represents banks, fintechs, and financial services clients on M&A, payments, and regulatory matters at Duane Morris. I'm also a core member of our banking, fintech, and digital assets and blockchain practices. Now, while we can't provide legal, financial, investment, or tax advice on the podcast, our goal for the Money and Banking Law Podcast is to inform and educate our clients and friends on both the fundamental concepts and structure of the banking ecosystem, as well as critical developments in the law and regulation of money and banking. Thanks for joining us today. As always, if you have any questions from any of our podcast episodes, please reach out to me at jsylvia@duanemorris.com. In this episode, we're talking about implementation of the Genius Act. Now, we've seen proposed rules come out, some previously, and in December, the FDIC came out with kind of a basic proposed rule around application and issues around kind of basic components of what the Genius Act requires them to come out with in terms of implementing rules. The OCC more recently came out with something much more robust, hundreds and hundreds of pages of reading for anybody that's interested and engaged in this topic, on the permitted payment stablecoin issuers that will be supervised by the OCC. Shortly after that, the FDIC came out with their proposed rules to more fully implement the Genius Act requirements. So both rules out now, both quite long, quite extensive, putting traditional bank regulatory guardrails in place for these PPSIs that are going to be supervised by the banking agencies. A lot of material there, a lot of material that we're going to cover going forward in more specific, in-depth interviews and podcast episodes. So stay tuned for that. In addition, one piece of the proposals that came out recently was from FinCen and OFAC, and that was related to implementing rules, the proposed rules, for the requirement that PPSIs establish AML-CFT compliance programs as well as OFAC compliance programs. And what we see with these rules that were proposed from FinCen and OFAC are really applying the very traditional AML program rules that exist for banks and other financial institutions, as that term is defined under FinCen's rules, and applying those rules to these PPSIs. So PPSIs are now going to be considered a financial institution under the FinCen regulations and the definition of a financial institution. And so what that means is they also are going to get the requirements that traditional financial institutions are already regulated under. And those requirements are things that you may have heard of, the 4 pillars of a BSA AML program. The 5th pillar, now it's customer due diligence, that may be getting shaped differently and put into one of the other 4 pillars. But, the 4 pillars of internal controls, training, having a BSA officer, things of that nature, having an independent audit, those 4 pillars that we have today for traditional financial institutions, those are all going to be requirements for the PPSIs going forward. In addition to that, there's going to be the customer due diligence obligations, enhanced due diligence where that's required. And then following that, we'll have also requirements to file certain reports, whether CTRs, SARs, or otherwise, by PPSIs, because that's the full scope of what financial institutions are already required to do. And then OFAC came in and said, okay, well, in addition to all the traditional AML and CFT requirements that are being imposed on financial institutions, we're also going to impose the same requirements that financial institutions have with respect to our economic sanctions regulations under the U.S. Law. And we're going to impose those for the PPSIs just like we have for the other financial institutions. So running checks, name checks and otherwise on institutions, people, companies, otherwise that they do business with, is that the PPSI being they do business with, making sure that we're not running afoul of any economic sanctions programs, making sure that we're not working with anyone that is on the SDN list or any of the other sanctions list. So very typical types of requirements for PPSIs, very expected in terms of what we were thinking was going to be happening, what was said all along following the Genius Act, and looking at these PPSIs as full-fledged financial institutions under the laws. One thing that I mentioned at the outset is that the FDIC and the OCC came out with their really robust proposed rules around PPSIs and the chartering and the process for becoming a PPSI if you're not a traditional financial institution, and looking at what the safety and soundness metrics and examination, supervisory cycle, all those things look like in that area of more traditional bank law, bank regulation. But I wanted to just have an episode real quick while I had a few minutes just to kind of outline some of the contours of what we're seeing on the AML side of things, AML CFT side of things now, excuse me, and an OFAC side, because that's where a lot of the conversation on the regulatory front has been, from my perspective, and existing in counseling clients that are in the digital asset space and stablecoin space, because there's still a very clear perspective that stablecoins, cryptocurrencies, digital assets are simply a way to launder money, and they're only used by criminals and so forth. And I obviously don't agree with that. I understand that it has been and will continue to be used by criminals and organizations of the like, but I don't necessarily agree that that's the only use case for digital assets generally. And so it's very expected, like I said, that FinCen and OFAC came out and said, look, these PPSIs are going to have rules under either the OCC or the FDIC regimes, depending on if they're state or federally chartered, and issues around AML are not going to be treated any differently than they would be for other traditionally regulated banks and financial institutions under those organizations. So therefore, we're going to consider them as a financial institution under our own definitions, and they're going to be subject to the same expectations: record keeping, reporting, information sharing, the 4 pillars, customer due diligence, enhanced due diligence where appropriate, and otherwise. And then, obviously OFAC on the economic sanctions side of things. So pretty expected here, but something that a lot of proposed and potential PPSIs are going to really need to pay attention to, because those are very robust regulatory requirements on the AML CFT side, in addition to the very robust safety and soundness mechanisms that the FDIC and OCC have put out proposed rules for as well. So that's all for today. If you have any questions, please feel free to reach out to me, jsilvia@dwaynemorris.com. If you have any questions, you can also reach out to any one of your other favorite Dwayne Morris lawyers. And as always, please be sure to like and subscribe wherever you get your podcasts. Be sure to like and subscribe here on YouTube or anywhere else that you might get their videos for the podcast as well. Until next time, I hope everybody has a great day. Thank you very much, and be well.